claims could never come through.
Well, I think it sort of did, Ms. Ratner. I mean, in Kurtz, in FMOMB, it was just true that if read one way, there was going to be a cause of action without any ability to bring the suit. And that was what, in all those cases, seemed absurd. That why would there be a cause of action if there's no way to bring a suit? You give with one hand, you take away with the other. But in this case, it's not, for the reason that Justice Sotomayor suggested. The FSIA is this background law that and it's trans-substantive. It assumes that there are going to be other causes of action all around, but that it is the thing that it tells you, for purposes of all those causes of action, when are you immune and when are you not immune? And here, the FSIA sets up a series of tests, when you're immune, when you're not immune. And so why shouldn't we just take that as like, okay, it's the FSIA that is the relevant statute here. The fact that there's causes of action, of course there's a cause of action in Article 3, as well as in many other statutes, but we don't take that to be, we don't look to those causes of action for purposes of deciding jurisdictional immunity for foreign agencies.
So, Justice Kagan, let me try to unpack two things from there. First, I don't want to give up on the Kurtz point, because I do think in Kimmel it was not 100% superfluous. The state defendants came in and argued there are state statutory waiver schemes, so the existence of a cause of action will not negate all claims against states. This court rejected that out of hand. That's page 75 of Kimmel, on which Kurtz was based. But moving to the FSIA, the notion that the FSIA is sort of the comprehensive scheme here and something, Justice Sotomayor, that you'd have to impliedly repeal, I think is inconsistent with the court's 2009 decision in Beatty. And there, this is involving the particular terrorism provisions as they relate to the Republic of Iraq. And there the situation was reversed. It was Congress allowing the president to remove a waiver of sovereign immunity. But the court there said, this is a specific targeted rule at a moment in time and a particular actor, and it doesn't need to reference the FSIA to
so I guess that
it.
seems right, that there could be statutes which don't need, if this statute gave you a cause of action and gave you jurisdiction under 1331, which it might, and which also said, there's an abrogation of immunity, then I am totally with you. It doesn't matter that the FSIA exists. But in fact, this statute does not do the last thing. So in that world, it seems as though, Congress knows that there's an FSIA around which provides the jurisdictional immunity rules. And so if Congress doesn't substitute in another statute, which does create a cause of action, it seems to me the right way to read what it's doing is to say we're providing a cause of action subject to the rules we know exist about jurisdictional immunity.
Justice Kagan, I think there are two problems with that. One is doctrinal and one is statutory. The doctrinal problem is that just gets us back to a magic words requirement that the court has refused to apply.
No magic words. They can abrogate immunity in any words they want to, but they have to abrogate immunity to replace the FSIA.
And that is exactly the question here. Has Congress clearly abrogated immunity here? And we think, through the sum total of its work, the answer is yes.
But a cause of action doesn't abrogate immunity. It just doesn't. There are causes of action all over the place that rely on the FSIA as providing the jurisdictional rules.
There are extremely few causes of action that expressly apply to foreign governments, foreign agencies, and instrumentalities. By our count, our petition has them at page 30. There's one about chemical weapons regulations, one about nuclear weapons regulations, and one about certain drug trafficking crimes. So that is, I think,
I'm not even
sure
that that's relevant if you're relying so much on Kurtz and Kimmel and so forth, where it was just a broad cause of action. So you can't kind of have it both ways there.
Justice Kagan, I am not trying to have it both ways. What I am relying on from Kurtz and Kimmel is the notion that when Congress expressly calls out this group of defendants, that's when we think maybe it's saying something on abrogation.